Now, the South African Municipal Workers Union is heading to the Constitutional Court. This so the legislation, which essentially prohibits municipal workers from holding political positions. It says the Municipal Systems Amendment Act, signed into law by President Cyril Ramaphosa back in 2022, is in contravention of the Bill of Rights, which state every citizen is free to make political choices. That includes the right to participate in activities of or recruit members for a political party and to campaign for a political party or cause. Now, Labour analyst Andrew Levy joins me to weigh in on this. Mr. Levy, good morning and thank you very much for your time. I must say this one is a very interesting case which has divided many. The legislation essentially is limiting citizens' Section 19 rights which relate to political choice and participation, something which some have welcomed. They've welcomed the limitation, saying it's necessary in the programs of depoliticizing administrative functions within municipalities. Where do you stand on this?
Well, before I say where do I stand, I'd like to just point out to listeners a very, very important point. People tend to think that, I have a constitutional right and therefore nobody else's rights matter. The Constitution is a living and breathing document, and it's a wonderful Constitution, but there are times where collective rights outweigh individual rights. Take, for example, the right to strike. It's a collective right. But the individual business owner has the right constitutionally to pursue his business without interference. Well, we believe as a society that we would be poorer if there wasn't the right to strike collectively, and that effectively is tough on the business owner. So what the ConCourt has to weigh here is the individual right to participate fully in political activity against our collective right to make sure that civil servants are not following a political agenda, which means we end up by law being made by civil servants and not by Parliament.
And it really does affect service delivery, because there were instances where municipal managers were leaders of a different party and they had to work with a mayor from another party. And there were also even instances where you had a municipal manager who, along with the mayor, are from the same political party, but the municipal manager at a political level is actually senior to the mayor. So in that instance, one wonders if there wouldn't be power struggles in a place where none should exist. I mean, you should be performing your administrative function, but it seems there's always just that mix of politics and administrative matters here.
I think you're absolutely right. And it's a very, very tricky problem. And it's one which the ConCourt is going to have to weigh the individual right to free political activity against our collective right not to be influenced by political agendas and to find people making decisions which are made not in the interests of the taxpayers or the ratepayers or the population, but rather following a party line. So the ConCourt will undoubtedly give us wisdom on this one, but I just need to say that obviously the right to political participation is a very, very important one. It's a very, very fundamental constitutional right. So this one is really going to tax the court, and I wouldn't like to try and predict which way it will go. So you said to me, where do I stand on this one? And the answer is, I'm not sure. I can see the arguments on both sides, and I think one has really got to apply the test of where does the balance of harm fall. Are we collectively more prejudiced and harmed by allowing political agendas to infiltrate into administrative decisions, or is the individual who can't take political action or join or hold political office more prejudiced than we are? And I look forward to the ConCourt's view on this.
It will indeed be our final arbiter, and I'm happy that you're so honest about it, to say you honestly don't know where you stand, because there have been a number of political and Labour analysts as well as political analysts who've weighed in on this matter, and they've also said, you know what, in as much as maybe Labour analysts should be in support of this legal action by SAMU, there's also the benefit that if you have such a legislation, it will level out the playing field for all workers, that there won't be an instance where perhaps your political credentials lead to you being elevated and made a municipal manager. Now anybody could get such a position, and it would be on merit, because it seems that if this legislation continues, what would happen is that a person who has very senior political credentials would actually have that as some sort of an albatross, that for that very reason they would be sidelined. So in this instant, then, it helps all of the workers inside a municipality.
I think there's much truth in that argument, and I'm sure it will be made to the court, and it touches on the thorny issue of cadre deployment, which frankly is not a good thing in my opinion. We must move, particularly in publicly funded service provision, to a meritocracy. The best people need to be there to do the job for the benefit of all of the citizens. So I'm quite sure the ConCourt will hear those arguments, and I look forward to seeing their judgment.
And there is that political element to it when you talk about cadre deployment, because SAMU is a very big union in local government. It's also an affiliate of COSATU. And then COSATU is an alliance with the ANC, but you had the president signing this piece of legislation into law, which essentially was saying we're about to do away with cadre deployment. Because if this is legislated as it was in 2022, it essentially said no more cadre deployment. If you mobilize for the party outside, it doesn't mean you will get a job inside the municipality.
Yeah, that's quite true. And once again, you know, the court is going to have to give us guidelines, hopefully in this case, which is, as an individual, you have the right to join, you have the right to your political views, you have the right to express those views, you have the right to express them in the ballot box. You can go to political meetings, you can speak, but the minute you hold office, and senior office in particular, we've got to balance the prejudices, and you know, I think there are real risks in that, and we've seen them. We've seen what happens. We've seen the infighting in municipalities where, you know, one week it's this mayor, and the next week there's a vote of no confidence, and you know, who suffers? The people who pay rates, and the citizens in that municipality.
Mr. Levy, just in closing, should it not be varied, perhaps, where it's a situation where the ConCourt decides that the most junior, if you're a general worker within the municipality, perhaps you can hold political office, but it would be more of those more influential positions where they would need you to not be holding political office?
Frankly, I can't see the court doing that, because what it seems to mean, almost in reverse, is that your power is dependent on how little you earn. And I think that throws up all manner of anomalies. It also opens up the possibility that people can deliberately take low-paid jobs, receive payment in a brown paper bag to make up the loss and wield that power. I could not see the court going that way. These constitutional rights are absolute, and I can't see a limitation of that nature.
Mr. Andrew, thank you very much for your time. That's Labour analyst Andrew Levy.